behalf of National Law University Odisha and Dinabandhu Sahu Memorial Trust. And this lecture that is happening in furtherance of NLUO's long-standing relationship with the trust. The lecture will be delivered by Hon'ble Mr. Justice Dipak Misra on the theme of personal liberty and dignity under the constitutional framework. Before we start with the event, I will just briefly introduce who as to Late Shri Dinabandhu Sahu is before we go into the lecture. So, Late Shri Dinabandhu Sahu served as an Advocate General of Odisha from 1961 to 67. He was also three-time member of Odisha Legislative Assembly in 1946, 1952 and 57, where he also served in the Council of Ministers, representing the Ministry of Law, Health and Development, Education, and Industry and Mining. He has also significantly contributed to the Indian freedom struggle by offering his legal services for free and defended many freedom fighters irrespective of their political affiliations. His additional public service contributions include being a member of the Mandal Commission, District Governor of the Rotary Club, being the President of the Akhil Bharatiya Tailika Vaishya Mahasabha for many years. And the Dinabandhu Sahu Memorial Trust has taken up the task of propagating the noble work that has been done by Late Shri Sahu. For today's lecture, I first call upon the Vice-Chancellor of National Law University Odisha to start the session by delivering a welcome lecture. But before that, let me just introduce her to you. Professor Ved Kumari has been teaching since 1983 and has a long-standing academic experience. She has formerly served as the Dean Faculty of Law at the University of Delhi. Her primary area of academic interests include juvenile justice, criminal law, gender discrimination, clinical education, judicial training. She is primarily very famous for her work in the area of juvenile justice and introducing restorative justice through various training workshops for judicial officers and social activists. She has joined NLUO last year as the Vice-Chancellor and is currently serving as such. Ma'am, I request you to kindly deliver the welcome lecture.
Thank you, Rebecca, for initiating this conversation. I'm very, very thankful to Justice Dipak Misra for very readily agreeing to deliver the first memorial lecture. And we are certainly very happy with the Sahu family, the daughter of Dinabandhu Sahu, sir, who has first earlier had initiated a gold medal in his name and now the memorial lecture. And I think they have been very supportive of the university, and it's a very noble cause to remember not only your parents as a parent, but also as a contributor in the legal arena. The topic Justice Dipak Misra has taken is very close to my heart as well, but of course from the woman's perspective, that where do women exist in the constitutional framework and what status do they have? And my understanding has been that actually women do not exist in the Indian Constitution, especially in the private sphere of their lives. Because by the interpretations we have created the interpretation of the law saying personal laws are not laws. And for me as a law professor, it has always been a question that we teach a whole 2 papers on personal laws, Family Law 1 and Family Law 2. And we also teach 2 papers on Constitution. And we still have the interpretation which says personal laws are not laws. So then what are they? I mean, there are legislations out there, and even then we say that they are outside the purview. So, and within the family sphere, the personal liberty and dignity of women is very much a challenge. And by law, we do not give them that personal liberty, especially in terms of the CRPC, the IPC provision of the exclusion of marital rape. So I think certainly I'm looking forward to some, I've heard and known Justice Misra at a personal level as well, being the chairperson, and he was the Chief Justice then at Delhi High Court. And many lectures I have attended. And he always comes up with lots of similes and good coining of new words, and I really enjoy listening to him. So I'm really looking forward to today's lecture. and his new insights and his new, and he puts a very different um, uh, the different take on a number of issues we've been talking about. So I'm looking forward to this, and I welcome you all. I'm very happy at the number of people who have joined today morning on a Sunday morning, and I can see Mr. R.P. Sahu now. So we are very happy at this initiative that we have the first memorial lecture, and we are very privileged to have the former Chief Justice of India, and well known for his articulation of new ideas in his judgment and his public lectures. So I welcome you all to this beginning, a new beginning in the memory and in celebration of Mr. Dinabandhu Sahu's contribution to law, to the legal profession, and to India as such as well. Thank you so much.
Thank you, ma'am. While Honorable Mr. Justice Dipak Misra needs no introduction, we have known him through his landmark judgments and the positions he has held. I would still briefly like to take you through the journey that he has had in the legal fraternity. So he started his career in 1977 as an advocate practicing in the areas of constitutional law, civil, criminal, revenue, service matters, sales tax matters, by practicing before the Odisha High Court and the Service Tribunal. He was then elevated as the additional judge of the Odisha High Court in 1996 and then transferred to the Madhya Pradesh High Court in 1997. Before joining the Supreme Court, he has also served as the Chief Justice of the Patna High Court and the Delhi High Court. And he was elevated to the Supreme Court in 2011 and was holding the position of the Chief Justice of India from 2017 onwards until he retired in 2018. Sir, it is an absolute honor to have you here. I welcome you on behalf of National Law University Odisha and the Dinabandhu Sahu Memorial Trust, and we really look forward to the memorial lecture. Sir, I offer the floor to you.
Professor Ved Kumari, Vice-Chancellor, National Law University Odisha, and I am obliged to add, a person who maintains intellectual integrity and her independence most ferociously. I say it from my experience as the Chief Justice of Delhi. Distinguished faculty members, family members of Late Shri Dinabandhu Sahu, my dear students, ladies and gentlemen, I am extremely delighted to have been invited to deliver the first Dinabandhu Sahu Memorial Lecture. Late Shri Dinabandhu Sahu, a fearless, upright, and independent personality, chose to become an advocate and fought for the patriots at the risk of life. The famous one being Basilgate murder trial. A lawyer par excellence, he held the office of Advocate General for a considerable span, and his manner and method of advancing arguments was discussed for a long time after his demise in 1980, and his name is still taken with great lawyers when law, presentation, and intelligence are discussed. Late Shri Sahu, as one is compelled to think, would not have been away from politics in the era he was paving his life. He was in the Council of Ministers of Odisha government in 1946, 52, and 1957. As the Minister of Law at the age of 36, he had introduced a number of path-breaking legislations. Late Shri Dinabandhu Sahu was a great humanist, an erudite and respected lawyer. He fought for noble and human causes. Having regard to the nobility and spirit of its humanism, I have chosen this topic today. Professor Ved Kumari has started with a note of pathos. I was immediately reminded of an episode that occurred in my court in 2018. My topic, I have a text, I'll do it. But I cannot but tell this episode. The matter relating to Satyabaini, popularly known as Kha Panchayat, was being argued. The lawyer who was representing the Kha Panchayats, after arguing for some time, he said, "May I be presented to ask the lady to argue if her lordship's permit?" I said, "All right, no problem. Let him argue. Let her argue." Look at the argument. She says, "We are doing nothing. We are not Kha Panchayat. We are not Panchayats. We are a group. And we guide these young people and young people how to choose partners and not to go hither and thither and create chaos in their life." My singular question to her was, who invited you? Why are you becoming an intruder? Are they minors? No. But she was obstinate. That here, as she said, the dignity of a woman, though recognized in the constitutional framework, the society, the family, the group, and all of us on certain occasions do not recognize. Time has come, we must accept. I don't believe he means she. In my judgments, I wrote she stroke he. She may mean he also. I don't believe in the English definition. You know, there is a distinction between author and authoress. An authoress is one who writes, a lady who writes, but doesn't achieve that greatness. But if she achieves greatness, like Emily Bronte, Charlotte Bronte, she becomes author. Look at that. This gender discrimination is destroying liberty and also dignity. I have not included it as a facet or part of my topic, but I was tempted, though intellectually, to say so at the beginning. Now, two words, liberty and dignity, when they are conceived of in the denotative sense and connotative expansive, a resplendent term sparks in the horizon, in the essential conceptual eventuality, and that is justice. All of us speak of law and justice. It is to be embedded in our minds that justice is the alien vital of an adjudicatory system. Learned Hand, one of the greatest judicial thinkers once said, I quote, if we are to keep our democracy, there must be one commandment: thou shalt not ration justice. Look at the words. I may clearly state here that it is true for any civilized democratic body politic. And one may immediately add that liberty is the filament of the concept of justice, because without liberty, the spine of democracy is damaged and the ligament is gravely injured. It is to be borne in mind that liberty does not come automatically. It is to be constantly fought for. One has to be vigilant to achieve liberty. Let me focus on the significance of personal liberty and dignity. Both the concepts are insegregable in a way. Personal liberty is a priceless constitutional right and fundamental human right. Centuries back, Aristotle had said, one line, the basis of a democratic state is liberty. What is this democracy? What is this democratic state? If you don't have the liberty, if you don't enjoy liberty. And that is why Justice H.R. Khanna, in a lecture in 1978, spoke, mark the words, I quote, liberty postulates the creation of a climate wherein there is no suppression of human spirits, wherein there is no denial of the opportunity for full growth of human personality, wherein head is held high and there is no servility of the human mind and enslavement of the human body, unquote. Spirit, mind, head is held high, and growth of human personality. It's a four-parted. That's what Justice Khanna meant. The value of personal liberty is indescribable. Do not describe. Do not give it a boundary. Let it be open so that you can really grow on this. A human being is the epitome of infinite prowess of the creative intelligence. Please understand what I mean by creative intelligence, the cosmic designer. But this embodiment of design of divinity is a glorious nothing, a hollow bubble without real enjoyment of liberty. Not for nothing, a great English poet said, I quote, please look at this line, how touching it is. Where liberty dwells, there is my country. It defies the political definition of state or country. It says, where liberty dwells, there is my country. Liberty, subject to valid restrictions in law, is a paramount human right. It has been said that citizenry liberty as a concept is respected as an abstract thought and more venerated as a concrete idea. When the thoughts get transformed into action, the acts become manifest and entered into the sphere of locomotion. This was the initial thought. In the beginning of when the Constitution of India was represented, liberty, life were really interpreted in a narrow way. But in the mid-70s, it really got a canvas. Justice Krishna Iyer, I am quoting this for the splendid prose. In Sunil Batra, he says, "True, our Constitution has no due process clause or the Eighth Amendment, but in the branch of law, after Cooper and Maneka Gandhi, the consequence is the same. For what is punitively outrageous, scandalizingly unusual, or cruel, and rehabilitatively counterproductive is unarguably unreasonable and arbitrary, and shut down by Articles 14 and 19, and if inflicted with procedural unfairness, falls foul of Article 21 of the Constitution." The time is never static. One may say time can stop. It doesn't stop. With the approach of time, the constitutional courts felt that the Indian Constitution is a living instrument and has immense potential of dynamic transformation, keeping pace with norms meant for progressive society. The citizens, in their turn, became conscious and vigilant with regard to their right to liberty. The constitutional courts became more active and gradually changed the concept by applying the hermeneutics of law. Then came the Dikebasu judgment. Dikebasu judgment categorically laid down many a guideline and mostly relating to pre-arrest, and that ushered in Section 41A in the Code of Criminal Procedure, which provided statutory safeguards. Section 41A has been interpreted with absolutely solidity by Supreme Court in two cases, Arnes Kumar versus State of Bihar and Rini Johor versus State of Madhya Pradesh. I would like to tell you the story behind Rini Johor. An IPS officer arrests two ladies from Pune, puts them into a train, handcuffs them, brings them to Bhopal. What for? Some cyber offense. There was nothing. The ladies were not able to tell their plight. The court engaged an amicus curiae. He really brought down everything, and the court eventually found there was nothing in the case. The officer was a henchman at someone's behest. Proceeding was quashed, and the court directed payment of compensation. I think it was 10 lakhs each. One was a doctor and one was a lawyer, the lady. Look at their plight. You see, bail or jail was talked about in 78. But time came in 20s, the topic was reiterated. In Arnab Goswami, the court said, now the debate has to be there with regard to bail or jail. And it inscribed that human liberty is a precious constitutional value which is undoubtedly subject to regulation by validly enacted legislation, and the high courts ought not to shy away from passing necessary order by invoking their inherent powers under Section 482 of the Code of Criminal Procedure so as to prevent abuse of the process of the court. Courts should be courageous. Citizens should be courageous as far as liberty is concerned. Liberty, I'll come later on. Let me read a passage from Hon'ble Mr. We are clearly of the view that in failing to make even a prima facie evaluation of FIR, the constitutional duty cannot be abdicated by the High Court and function as a protector of liberty. Courts must be alive to the need to safeguard the public interest in ensuring that the due enforcement of criminal law is not obstructed. The fair investigation of crime is as an aid to it. Equally is the duty of the courts across the spectrum, district judiciary, the High Court, and the Supreme Court, to ensure that the criminal law does not become a weapon for the selective harassment of citizens. Unquote. I am reminded of Henry Patrick, who said, and it's a great speech in American history, I do not know for what price others can do. As far as I am concerned, give me liberty or give me death. Look at the powerful language. Look at the feeling. And that is what the court has in mind when the court says there cannot be selective harassment of citizens. I may clarify here, two aspects are manifest: value and the pricelessness of liberty, that is sacrosanct, and as a right, it's not absolute. But the regulation is absolutely minimal. Otherwise, it will send a chill in the spine, fear in the mind, devastate your marrows. Let's go to dignity. When I say go to dignity, dignity cannot be separated from liberty. Dignity and liberty both are connected with choice. What am I if I don't have the choice which is legally acceptable? I am not a human being. I don't have the human rights. Choice has its primacy. and choice is primary, and choice is the pillar of liberty, and choice is the sacrosanct principle of the dignity. All of you must have read, I assume so, and I think correctly, Sapya Jahan case, popularly known as Hadiya case. She fell in love. She wanted to marry. Parents, local people, many people came. How can she marry X? She was a major. Ultimately, the court allowed the habeas corpus. She was allowed to go with her husband. There the court said, with regard to choice, and I quote, when the liberty of a person is illegally smothered and strangulated, and his or choice is throttled by the state or a private person, the signature of life melts. May I pause here for a while? May I pause here for a while to explain what is signature melts? All of you sign every day. That is the signature of your life. If you lose your choice to sign, the signature evaporates. Signature melts. To continue the quotation, the living becomes a bare subsistence that is fundamentally an expression of acrimony, which gives indecent burial to the individuality of a person and refuses to recognize the other's identity. What happens when you lose your individuality? What happens when you lose your personality? You become a non-person, an unperson. UNPERSON. Nobody can make you that, whether the state, a group, or a private person. Personality of a person has its sacrosanctity and is to be maintained, sustained at any cost. No one has right to touch it, to smother it, to make him an person. Some people think physical torture is only torture. Mental torture is only for marital relationship. No. In a custodial torture, the mental torture matters. You can't mentally torture an accused who is in custody or a convict who is in custody. You have no right. A case came before the court when a man was mentally tortured and the court granted compensation because that was constitutional tort. I read a passage earlier. Now I am reading few lines from Azam's case. When you torture mentally, you really assault the dignity of a person. The court says the sustenance of such dignity has to be the superlative concern of every sensitive soul. The essence of dignity can never be treated as a momentary spark of light, or for that matter, a Shakespearean brief candle. The spark of life gets more resplendent when man is treated with a dignity sans humiliation, when a dent is created in the reputation. Humanism is paralyzed. No one likes to see humanity or humanism being paralyzed. All of us are human beings, and we fight for it all the time. Decade changes. Decade has many years. With the passage of time, privacy became a fundamental right. And after privacy was declared a fundamental right under Article 21 of the Constitution, many paths opened to bring in many ideas and many landmark judgments were delivered. All of you know the case of Navtej Singh Johor, where the Supreme Court declared Section 377 of IPC as unconstitutional. Emphasis was given on the consent. Consent is the fulcrum. Without consent, you can't do anything. I quote few lines from that decision. The overarching ideals of individual autonomy and liberty, equality for all, sans discrimination of any kind, recognition of identity with dignity, privacy of human beings constitute the cardinal four corners of our monumental Constitution, forming the concrete substratum of our fundamental rights that has eluded certain sections of our society who are still living in the bondage of dogmatic social norms, prejudiced notions, rigid stereotypes, parochial mindsets, and bigoted perceptions. Why? No reason. Some people say it's a disease, and some announce it's a perversion. The court said what nature gives is natural. Simultaneously, the court added, if it is a choice, it's a facet of Article 21. It's fundamental to the fundamental right. The rainbow of that right cannot be scuttled. And rest is history. The other day I went to the other day, it was 2019. I went to the hospital to see an elderly man whom I know closely. He was on a ventilator. I asked, will he come back? The relative said, we don't know and we have grave doubt. Then I asked them politely, why did you put the person on the ventilator? So we do not know. Then I told them that right to die with dignity is a fundamental right. You cannot destroy your life. That's not a part of Article 21. You don't have a right to die, but you have a right to die with dignity. When euthanasia case was heard in 2018, there are many groups supporting euthanasia. There are many groups criticizing it. And there is a third group who said, let the law come. But the Supreme Court said, we will lay down the guidelines. People will follow with time. Because children can't decide. Doctor cannot decide. Let law decide. Right? The court said, life without dignity is like a sound that is not heard. Dignity speaks. It has its sound. It is natural and human. It is a combination of thought and feeling. And it deserves respect. And when any person is dead and described as a body, the court recognized that even a dead person has dignity, and such a respect or dignity of another is the constitutional norm, constitutional value, constitutional sanctity. It would not amount to an overstatement if it were said that intrinsic constitutional values equal mutual insurance of respect and concern for each other's dignity. Let me go back to history. I know I'm still within my time frame. It was the time of Second World War. It was over, almost, so it's over. Mussolini and his wife were made to stand beside a wall. His wife said, don't kill him. Wife's concern. Mussolini came to the front. If you want to shoot me here. And he was shot here. He died. His body was hung up. His body was carried on the streets. Extremely ill-treated, which I can't describe. I'm not saying he was correct in history. But to treat such a person with such kind of treatment was absolutely human indignity. This reached Hitler's ears. He married Eva Braun and said, on one condition, he asked his people to come, shoot me or burn this bunker. He said, they said, we'll burn the bunker because what we have heard. They burnt it. Nobody saw the dead body of Hitler or Eva Braun. Please, for God's sake, don't think I'm supporting their role in history. It's obnoxious. But the way Mussolini was treated, no human being, how dreadful he is, should be treated after his death. I think all of you must have read Katara case. The boy fell in love. The brothers came and cheated him, called him from a restaurant, took him, and they cut him into pieces. Nobody could identify. The mother could identify with a lot of difficulty. And the court said, this is assault on the dignity of the dead. You can't do it. having stated certain aspects with regard to liberty, dignity, and intellectually propelled to speak on gender justice by the Vice-Chancellor. I am not saying the other judgments on gender equality or other concepts, but remember, it was Robert Louis Stevenson first who talked about gender equality. Now let's come to the conclusion. But prior to that, I must say, the university must be obliged to the family of late Dinabandhu Sahu. And I am greatly privileged and honored to have been invited. I repent that I could not see Dinabandhu Babu while he was alive, though I had joined the bar, but he was not coming to the bar. And you see, as a young boy at the bar, young man at the bar, I did not think it appropriate to go to his house because he was yelling at that time. That's what I was told. In conclusion, I would like to say that no one should conceive of any theory of adjustment with liberty and dignity. No imaginative anarchy can be ushered in to jeopardize liberty and send the inherent concept of dignity on vacation. Every person must feel that the soul of liberty and the marrow of dignity and never learn the description or yield to the idea of abandonment. Never put liberty or dignity, an iota of it, trace of it, scintilla of it on the ventilator, even at the advice of the greatest physician. They can breathe themselves, they can live themselves, as long as people like you are there to listen about liberty and talk about dignity. Thank you. Thank you very much for being patient.
Thank you, Justice Mishra, for your lecture and your interesting take on liberty and dignity. We now move on to the last step of the event, that is concluding remarks. For that, we have Professor Rangin Tripathy with us. Dr. Rangin Tripathy is the Registrar currently at National Law University Odisha. He has been working at NLUO since 2010, and his area of academic interests are constitutional governance, civil liberties, criminal law, and human rights. His current research focuses on functioning of institutions within constitutional democracies and the way they affect realization of democratic rights. He was a Fulbright postdoctoral research scholar at Harvard Law School from 2019 to 2020, where he researched on the competing methods of appointing judges in democracies. His doctoral thesis is the first work of its kind in India on performance evaluation of judges in the higher judiciary. Rangin sir, I now call upon you to deliver the concluding remarks and vote of thanks.
Thank you, Rishika. Thank you so much. Firstly, I would like to thank the entire family of late Shri Sahu, who have kept his legacy alive and who have been associated with our university for a very long time. And it's because of them that we are having this opportunity to organize conversations on such important topics. So thanks a lot to you, sir. I see Mr. R.P. Sahu who is here today. So thanks a lot to you for showing the interest in keeping the legacy of Late Shri Dinabandhu Sahu alive and allowing us to be a part of that legacy by associating our institution with him. Thank you so much, sir. I thank Justice Dipak Misra, who as always has delivered an extremely erudite and insightful lecture, and he was extremely cooperative with us. I still remember when Professor Ved Kumari reached out to him. I was sitting in the same room, and this is not the first occasion that we have had the chance to listen to him. We have had the pleasure of him being the visitor to our university in the past, and we hope that after the pandemic, during the pandemic there has been a hiatus, and now we hope that we get to associate with him even more, and have the occasion of listening to him, taking advantage of his vast amount of knowledge more often. I thank Professor Ved Kumari, our Vice-Chancellor, my colleagues, Rishika, who very kindly agreed to moderate today's event, and all the students, all the audience members. As we can see, we had more than 150, participants who are interested to listen to this lecture, and a lot of them are not from the university. So one of the fundamental objectives of this memorial lecture, that is to reach out to a wider audience and have them be a part of this conversation which this Dinabandhu Sahu Memorial Lecture is supposed to initiate. I think that has been fulfilled, and we hope to continue this tradition every year. And thank you, everybody. Thank you so much.